Hey everybody, this is Mr. Moppet coming at you with another AP Government video. This is our second video focusing in on topic 3.11. And last time we were here, we were talking about kind of the basis for civil rights in America stemming from the 14th Amendment Equal Protection Clause, and talking about how African Americans in particular were facing challenges to this idea of equal protection of the law as it pertained to the 15th Amendment protection of the right to be able to vote regardless of race or conditions of previous servitude. We talked about how southern states attempted to block black Americans in reality from voting by implementing things such as literacy tests and poll taxes, things like that. But unfortunately for people of color in the United States, specifically the South, it wasn't just discrimination as it pertained to voting that was going to be problematic. We also saw discrimination as it pertains to social life in society with regards to what we called Jim Crow laws. Now, following the departure of Union troops at the end of Reconstruction in the mid-1870s, whites that were now going to be in control of the government are not only going to strip black Americans of the right to vote in reality, but of any attempts to try to integrate in society socially. Jim Crow laws were laws that segregated the races, white and people of color, in all aspects of public life, be it from a hospital you may have been born into, to the school you attended, to the neighborhood you lived in, to the person you wished to marry, literally to the graveyard you were buried in. From the cradle to the grave, you were segregated by law in Southern society. Once again, this is not just segregation based on custom and tradition, which was found everywhere in America, unfortunately, but this was by law. So in other words, you could be arrested, you could be fined, you could even be jailed potentially for violating these laws, not just customs, but laws. And if you were wondering, well, how can this be? How can you have legalized segregation if you have the 14th Amendment Equal Protection Clause? Well, you might remember the infamous case of Plessy versus Ferguson from 1896 that stipulated that as long as a separate but equal guideline is followed, then segregation doesn't violate the 14th Amendment Equal Protection Clause. But anybody that lived in the South, as pictured here, as pictured right here, will realize that separate is not equal. Separate means separate, but it's, as you can see here, not being implemented in a truly equal way, and that applies to basically every aspect of public life if you were a person of color, and most importantly, applied to the world of education. Public education, just like everything else in the South at this point, was separated by law. So whites went to their own schools, people of color went to their own schools, and it was not equal in reality. If you were black and you went to school, your school building was not as new or well maintained as the white one. Your resources, such as textbooks, for example, are not going to be as nice or as modern as the white students. You're not going to get teachers that are as well trained as the white students are going to get. So even though, on paper, both whites and blacks had schools, they were not equal in reality. And this is going to be the basis for a lawsuit, a class action lawsuit initiated by the NAACP that is going to be one of the most important, significant cases in American history. Of course, I'm talking about the case of Brown versus Board of Education. This is a case that you are required to know for the AP test, so it is very important. Now, the basis for this case was that there were several families in the Topeka, Kansas area who lived closer to a white school than the school for black students that was further away. And in fact, these students had to travel a considerable distance, having to walk over train tracks and things like that to get to school. They therefore wanted to attend the closer school that just happened to be a whites-only school. Now, of course, this is going to be denied because Kansas, even though it was not a former slave state, was in reality a Jim Crow state at that time. Now, leading the NAACP and the class action lawsuit is going to be lawyer Thurgood Marshall, pictured right here. Now, Thurgood Marshall is going to be nothing short of a legal genius, and in fact, he will go on to become the first African American Supreme Court justice. But years before that happens, Thurgood Marshall is going to be tasked with leading the class action lawsuit with regards to segregation in Topeka public schools. Now, what Marshall and the NAACP has to overcome is that already pre-existing precedent of Plessy versus Ferguson. The idea being that, segregation is totally constitutionally protected. Separate but equal is fine. And on paper, yes, whites and blacks had, schools. So how do you overcome that precedent? Remember, precedent is not easy to change. You typically have to provide something new, something that the court was not aware of, or something that is going to be able to be provided that just simply didn't exist when that previous precedent case was established. And to be able to do that, Marshall's going to be using psychologists to engage in something called the Dahl test. And the basic gist of how this Dahl test worked was that students that attended segregated schools were interviewed by child psychologists. And we're talking very young children. You're talking about 5, 6, 7 years of age, something along those lines. And they were shown a series of dolls. And, one of the dolls was white and the other one was black. And they were asked certain questions about themselves and as it pertained to the dolls. So in other words, students were asked, are they white, are they black? And they would, of course, commonly self-identify correctly. And then they would be asked questions about the dolls themselves, all right? Questions dealing with, for example, how pretty they are, how intelligent they are, things along those lines. And the positive responses were commonly associated with the white doll and negative responses associated with the black doll. And that included responses from black children themselves, that black children would associate a white doll as being prettier and smarter than a black doll. In essence, that children were already picking up on the idea that whites are superior to people of color, and that they, as children of color, are already inferior, that they are already less than, they're already aware of this at a very young age. And, what is going to be a prevailing factor in explaining this? Well, the fact that they have to go to segregated schools, that from the mindset of a child, they have to go to their school because they're not good enough to go to the white school, and they're not good enough because they're black. And so the idea being is that the very existence of segregated schools is going to create inequity in the self-esteem of these children, creating a pathway to lack of equality as an adult. In other words, if you go through a dozen plus years of formal public education where you are segregated and in essence have been taught and reinforced year after year that you're not good enough, you're not talented enough as a white person, then that's going to set you up for failure as an adult. That that government has instituted a policy where you are less than, that you are less than equal. And because of that, profound argument in terms of the lack of inequity, in terms of the effects of the segregated public school system, public education, schooling, Supreme Court, led by Chief Justice Earl Warren, his first major case leading the bench, will be able to consolidate the entire Supreme Court in a 9-0 ruling in favor of the NAACP and striking down segregated schools, not just in Topeka, Kansas, but issuing a reversal of the precedent of Plessy versus Ferguson, at least as it pertains to public schools. That bottom line, segregated schools are a violation of the 14th Amendment Equal Protection Clause. So this is a major victory in the fight for civil rights. But of course, this is only pertaining to public education. And note, all right, this is only pertaining at the time, to those states that are willing to implement it. Okay, you have to remember that there's going to be many states that are not going to just accept the Supreme Court's ruling. You might be familiar with the Little Rock Nine that would have to use federal escorts from the 101st Airborne to be able to attend school. So this is going to be a slow, arduous process to try to have to integrate the schools. For example, 8 years later, when we see James Meredith attempt to try to, and James Meredith is pictured there in the center, will attempt to be the first African American student at the University of Mississippi, Ole Miss as it's commonly called. Just like with Little Rock a few years earlier, this is going to require federal intervention, that the federal government is going to have to escort Meredith by force into the university. So time and again, this is going to be problematic in terms of the ability to enforce the court's rulings on this issue. Now, note, what was seen as a victory for civil rights for Black Americans in public education through the courts, it's going to spark a growing civil rights movement in the United States in general for African Americans. The problem, though, is that in the 1950s, President Eisenhower was pretty lukewarm on the idea of civil rights. He didn't really want to rock the boat, so to speak. It was seen as a little too controversial for him as a moderate. But when we get to the early 1960s, that will begin to change. And even though JFK on the campaign trail in 1960 is not going to be a full-throated supporter of civil rights, so as not to alienate his Democratic Party base in the South, about a year into his presidency, he is going to come out in support of full civil rights for Black Americans. And he is going to be expressing his explicit desire to have a Civil Rights Act be passed. The problem, though, for Kennedy is that he is trying to win support for something that would be nothing short of revolutionary in the South. And Southerners had no desire of changing their entire way of life because some Yankee, if you will, Kennedy was from Massachusetts, wanted to make it happen. They bottom line were not going to let what they would consider to be modern carpetbaggers change their way of life. And so, unfortunately for Kennedy, he is not going to be able to successfully get a civil rights bill passed into law. Following his assassination, Lyndon B. Johnson will become president, and Johnson's going to be able to bring something to the table that Kennedy could not. And that's the fact that Johnson was a Southerner. Lyndon Johnson was from West Texas. He had grown up with segregation. He knew the Southern way of life. And when Johnson comes out in full support of civil rights and is demanding that Congress pass a civil rights bill, that's going to have a little bit more force behind it, because this is not some northern interloper. This is one of their own from a Southern perspective. This is a Southern white guy that knew the way of life, that knew what Jim Crow was all about, and even he is saying that we have to overcome this. We have to move on. We actually have to make civil rights a reality for Black Americans. And when we come back in our next video, we're going to see how the Johnson administration is going to be able to work with Congress to get some very important milestones achieved regarding civil rights. Civil Rights Act of '64 and the Voting Rights Act of 1965. We'll see you next time.